I'm Drew Stevenson, and this is a lecture for my professional responsibility class about ABA Model Rule 4.3, dealing with an unrepresented person. Rule 4.3 has only one section, but it's a long paragraph, so I'm going to break it into 3 slides for the sake of clarity. Let's begin. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. By disinterested, we mean neutral or looking out for both sides, and the main point here is to avoid misunderstandings about whose interests you're looking out for. And note that this applies only where you're having conversations or maybe correspondence on behalf of a client. So if some random person asks your opinion on a legal matter or what you think of a judge or something like that, this rule doesn't apply. Also notice that this part of the rule is about what you can't say, and that you can't state or imply that you are representing someone or looking out for their interests if you're not representing them. I'll give you a quick example. Suppose you're talking to a potential witness in a matter on which that you're working on for a client. And this could even be a favorable witness. So someone whose interests are not going to be adverse to your client could be someone whose interests align with your client. Even so, be careful not to assure that person that you're looking out for their interests if you're not representing them. Let's move on. When the lawyer knows, or reasonably should know, that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. So this part of Rule 4.3 creates an affirmative duty to clear up any misunderstanding. In fact, to speak up when a misunderstanding becomes apparent and explain that you are not their lawyer, they are not your client, and what that means. Let's continue. The lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel if the lawyer knows, or reasonably should know, that the interests of such a person are or have a reasonable possibility of being in conflict with the interests of the client. Yikes, don't give legal advice to an opposing party who is pro se. That's an obvious conflict of interest, and the same would apply to someone who's a potentially adverse party who is currently unrepresented. Let me give a quick example. Suppose you represent a landlord, an owner of an apartment building, you're visiting the premises, and one of the tenants stops you in the parking lot and asks you a question about their lease. Well, that's exactly the type of situation this rule is intended to cover. You should not give any legal advice to a tenant if you're representing their landlord already, except the advice to talk to another lawyer, to get another lawyer. Now, if that tenant stops you and asks you for directions or what time it is, or your opinion about the latest Supreme Court nomination or something, or a famous case they've heard about, go ahead and answer that question that's not related to the matter that you're representing the client in. So now let's move on and talk about the comments. An unrepresented person, especially if they're inexperienced in legal matters, might misunderstand and think that you are neutral or disinterested in that matter in terms of your loyalties, or that you're some sort of objective, disinterested authority on all questions of law, even when you have a client right there. So to avoid misunderstandings, always identify who you are representing, who the lawyer's client is, and if they have interests that are opposed to your client, it's probably necessary to explain that to the unrepresented person. Now, Rule 4.3 distinguishes between parties adverse to a client and those who are not. And for unrepresented adverse parties, the rule prohibits giving any advice apart from the advice to obtain counsel. I also want to add, many misunderstandings arise when lawyers are representing a corporation or some sort of organization or entity that has a lot of unrepresented constituents in it. Those people are not your clients, the entity is. And we have a whole rule just about representing organizations, Rule 1.13. And Section F of 113 basically overlaps with Rule 4.3 in the context of organizations. Let's move on a little bit more detail about this distinction that we make between an adverse party and a non-adverse party. It does depend somewhat on the setting in which the comments are made and the experience and sophistication of the unrepresented party. We're particularly concerned about people who are not familiar with our legal system. If the unrepresented party is a pro se lawyer or a former lawyer or law professor, you're going to have a little more latitude about the type of conversation you can have, because we're not as worried about a misunderstanding or that you will manipulate or exploit that person. Also notice that if the opposing party is pro se, then obviously you have to talk to them. It's permissible to negotiate the terms of a transaction or settle a dispute with an unrepresented person. I do want to tell you about a famous case that's an example of what this rule is about from here in Texas in the late 1980s. A Coca-Cola delivery truck collided with a school bus that was full of kids on a bridge over a high ravine. This took place in Alton, Texas, down near McAllen. This made national news. A lot of the children died, and the Coca-Cola truck driver survived but was injured and was hospitalized. So the lawyers for Coca-Cola visited him in the hospital, the story goes, and identified themselves as the company's lawyers, but didn't explain to the truck driver that they weren't representing him, or that he could be in a lot of hot water, or that he should get his own lawyer. They just said that they were the Coca-Cola lawyers, and they asked how he was doing and what happened. And he admitted to them that he was driving impaired at the time of the accident. He had a substance abuse problem. So think about it. The lawyers have a duty now to go tell the management at Coca-Cola about this information. It's very relevant to their client. And Coca-Cola, the employer, is likely to raise this as an affirmative defense to escape vicarious liability at trial and put all the blame on the truck driver. And no one thinks that that truck driver really understood the lawyers weren't representing him. In fact, he was probably worried about the lawsuits from the victims' families, the families of the children that died, and thought that the company's lawyers that he worked for and who owned the truck he was driving were on his side. So the lawyers in that case had an affirmative duty to explain this to him and explain the situation, explain that he should be careful and that they weren't looking out for his interests, that he should get his own lawyer and so on, and they didn't do that. I mentioned this case actually earlier in the course in conjunction with another rule and in connection with the plaintiff's lawyers. Okay, let's move on. So going back to this situation where you're working on a case, whether it's a transaction or settlement and litigation, and the other side is pro se, it is permissible to negotiate the terms of a transaction or settle a dispute with an unrepresented person. So if you explain the situation and your role first, then you may inform the person of your client's terms to enter into an agreement. You can even draft documents that the other party may have to sign, that unrepresented person, and you can explain what you think the document means. With the caveat, this is your opinion, and if they want to ask questions or get clarification, they should get their own lawyer or ask another lawyer. So you can inform them of your client's terms, you can draft and prepare documents, and you can explain your own view of the meaning of documents and the respective legal obligations of the parties. Here's a review question to see if you've been paying attention. An attorney represents a client in a negotiation to buy a business from the owner who is unrepresented in the matter. Is it permissible for the attorney to reassure the owner that the attorney is looking out for her interests as well in the sale? A, yes, even if untrue, the lawyer owes no duty to an opposing party. Or B, no, the lawyer may not claim to be disinterested in such a situation. Hopefully you know the answer to that. It's supposed to be an easy question, and if not, you should probably rewatch this video. You might not have been paying attention. And that concludes our lecture about ABA Model Rule 4.3.